Good afternoon. We're just going to give folks a minute or so to join and then we'll get started. If you're just joining us, we're just giving folks a few seconds to jump on and we will get started shortly. Okay, looks like that has slowed down. So we'll go ahead and get started while folks continue to join when we get through our housekeeping items. So good afternoon again. Thank you for joining our webinar this afternoon on the 2026 election, what local leaders need to know for ballot measures and candidate elections. I'm Melissa Keene, the Director of Enterprise Programs and Special Projects here at ILG, and I will be your host and moderator for this afternoon's webinar. So a quick overview of our agenda for today. Just going to do a quick welcome and introductions and share a little bit about ILG. And then we're going to hear from our two presenters, Dave Bainbridge and Craig Steele. And then we will go into audience Q&A and we will wrap up and adjourn by 1:30. Some quick housekeeping items before we jump in. You probably noticed that you are muted as you joined the webinar. We are going to keep you on mute for the duration of today's webinar, just given the size of our audience, but that doesn't mean you can't engage with us. So please, if you have questions throughout today's webinar, you should see a Q&A box at the bottom of your screen. You can type questions or comments or anything into that box at any point during today's session. We'll be watching that live and responding to any logistical issues you have, and then pulling any substantive questions you have into that queue for our Q&A at the end of the session. You also probably heard that we are recording today's webinar, so we will be recording and sharing that recording as well as the slide deck and materials shortly after today's session. If you need captions, you should also see a note in your controls around showing captions. So if you click on that, you'll have the option to see the transcript and turn on captions for the session if you would like. So quickly, if you aren't super familiar with ILG, just want to share a little bit of background about us. So we are a nonprofit training and education affiliate founded by the League of California Cities 70 years ago. So we work with cities and counties and special districts statewide to provide practical and easy to use resources so that you all as local agencies can more effectively implement policies on the ground. We do that in a number of ways through education and training, like this webinar and conference sessions and longer format training. But we also provide technical assistance and capacity building and convening services for public agencies statewide. And we do that in four main issue areas. We have a focus on leadership and governance, which is connected to today's conversation, where we talk about all of the foundational pieces that you all as local agencies need to comply with, that regulatory and legal framework, how to work together as a council and board and elected body and work with staff in the community, etc. In addition to that, we also have programs focused on workforce development and civics education, public engagement, and sustainable and resilient communities. So if you aren't connected with us already, I encourage you to go to the website, check out our free webinars, our free resources, and of topics that might be able to be helpful to you as local agencies. So with that, I'd like to introduce my panelists for this afternoon's conversation. I'm joined by Dave Bainbridge, who's Senior Counsel with the Fair Political Practices Commission, and Craig Steele, who's a shareholder with Richards, Watson, and Gershon. And they both have a wealth of knowledge in this space and been working with local agencies on these topics for a number of years. So I'm going to turn it over to Craig, I believe, to kick off today's conversation.
Thanks, Melissa, and good afternoon, everybody. Thanks for attending, and thanks also to the ILG for putting this seminar on, and also really appreciate the FPPC, Dave, for participating. I think it's great that we can all kind of try to get on the same page as we kick off a couple of election cycles in 2026, where a number of public agencies that I'm aware of are already thinking about for either June of this year or November. So it's great to kind of talk about the legal guardrails that we all have to operate within and get the perspective of the public agency side that I'm representing, as well as the regulator side, the FPPC's perspective on these issues, as we get started down this path. So let's talk about the legal framework for putting measures on the ballot. There's really three sort of theories of putting ideas before the voters. And in most cases, let's face it, we're talking about funding measures in today's day and age, whether it's a special tax or a general tax measure like a utility users tax, a transient occupancy tax, or even some general obligation bonds. Those kinds of things are usually what we see the most of. And the framework for doing that is either statutory or derived from the state constitution, or in certain cases, it's kind of judge-made law that's mostly pertaining to some Prop 218 issues. But those are the three sort of main legal authorities for going to the voters and asking them what they think. Um, then there's a statutory authority in the government code for public agencies to lobby the legislature and tell them the public agency's position on what the legislature ought to do in terms of adopting or not adopting laws. Importantly, though, there's no legal authority for public agencies to lobby the voters. And the voters have just as much authority to adopt laws as our legislators do. And so it's interesting that we have a statutory authority to go to Sacramento or go to your and lobby the legislators, but you can't use public resources to lobby the voters. Next slide, please. What we're really talking about in all of this, and when we talk about public resources, but for the most part, we're talking about the use of public funds in an election context. And the late, great treasurer of the state of California, Jesse Unruh, had a famous quote, money is the mother's milk of politics, and it's really all about the money. What we're talking about today is the use of public resources in candidate elections to some extent, and as well, more, we're going to talk about ballot measure elections. Um, And while we're going to focus a lot on ballot measures, the rules do apply to candidate elections as well. And many of you will be either candidates for an election in 2026 or staff at an agency where there will be an election in 2026. And we got to be cognitive of the fact that the rules we're going to talk about now really also apply to candidate elections. You can't spend public funds to support or oppose a candidate for election. That's, I think, pretty intuitive, especially for staff. But there are lines that have to be drawn, and you should be aware that the lines I'm going to talk about and Dave's going to talk about apply to candidate elections just as much as ballot measures. Next slide, please. And when we talk about the application of public resources to ballot measures that either are put on the ballot by an initiative or a referendum, or by the legislative body of an agency itself, when I say public resources, it's all about the money. And the question is, who can spend money in an election? What applied or not applied, and when can they be applied? And there's a very clear line between preparing for a ballot measure, preparing to put a measure on the ballot, and public agency activities in that context, and what happens after there is a quote unquote clearly identified ballot measure. Before there is a clearly identified ballot measure, there are kind of a different set of rules about the application of public resources. A public agency can spend some money, some staff time thinking about whether to put a measure on the ballot, and that's under one set of rules. But once the decision is made to ask the voters what they think, that's a clearly identified ballot measure, and a lot of the regs and rules and regulations that Dave's going to cover really clearly kick in at that point. There's also a fine line between information and advocacy, and I'm going to talk about that in a few minutes. The law says there's a line between information and advocacy. I think people trying to comply with the law and lawyers trying to advise about what that line is have trouble sometimes making that distinction, figuring out what activity is on what side of the line. And also a question of whether a public agency is required to present both sides of an argument in relation to a ballot measure or just one when we talk about information. And I'm going to cover that in a minute. And I think as time has gone on, and I've been talking about this for a number of years, I've become more comfortable with the fact that it's not we're not required to be a completely balanced communicator. We're not required to size opposition to ballot measures, especially when the opposition to ballot measures is based on emotion and not necessarily based on fact. Next slide, please. Everything kind of is derived in this context from a case called Stanson versus Mott. It was a case of the California Supreme Court in 1976 that really set out the initial set of rules. These are judge-made rules at that time. And everything regarding the use of public resources in the political campaign context really is derived from Stanson versus Mott. And the holding in that case, which is that without statutory authorization, public agencies may not expend public funds to influence the voters for or against a measure. And the historical context for this is really interesting because everything in that era, 1974 to 1979, arose out of the Watergate scandal. The Political Reform Act, which is the law that Dave is in charge of interpreting and enforcing, was a direct reaction to the Watergate scandal. The laws that I'm going to talk about in this presentation about public agency expenditures were all enacted post-Watergate and arising out of Stanson versus Mott. There was an incredible focus on anti-corruption type of activities. And so, everything over the course of the last 50 years that we've been trying to implement and interpret really arose out of the Watergate scandal. And the money quote from Stanson versus Mott is: the selective use of public funds in election campaigns, of course, raises the specter of an improper distortion process. It's the concept of government putting its thumb on the scales of the election. And that's why there's statutory authority to go to the legislature and say to your legislator, hey, pass this law. But there's not authority to go to the voters and spend money to say to the voters, hey, pass this law, because of this concept of government improperly distorting the electoral process by spending taxpayer dollars to tell the voters what to do. Next slide, please. Stanson also emphasizes the informational role that public agencies must play. The court is saying public agencies don't have to be silent with regard to a ballot measure. There's an impartial informational role that public agencies and public officials can play to inform the voters, as long as they don't get into actually urging the voters to take a certain result. Stanson also notes the possibility of personal liability. Let me repeat that: personal liability for public officials who authorize improper political expenditures in the absence of due care. Why do I take this stuff and other lawyers take this stuff so seriously? Because of the line in Stanson versus Mott and in the statutes we're going to talk about that impose personal liability for improper political expenditures, and in the words of Stanson, in the absence of due care, which means without caring about whether it's right or wrong. Stanson raised this dichotomy between the campaign activity and informational activity. It recognized that it's not necessarily a bright line, but it does emphasize that those are two different concepts: the campaign activity being improper, the informational activity being proper. In my view, based on Stanson and the cases that have come since, and enforcement activities of the FPPC, I believe there's an envelope that's large enough for a public agency to inform its constituents about the content of a ballot measure, why it's needed, why it's been proposed, without advocating for a particular result in the election, and to do so lawfully. And so I don't think it's worth pushing the envelope because the penalties for stepping outside of that informational rule are pretty severe. Next slide. First statute I want you to be aware of is Government Code Section 8314, which is the statute that says that it's uh, uh, a, a misdemeanor for a public official, local agency officer, employee, or consultant may not spend or authorize the expenditure of public funds to support or oppose a candidate or ballot measure, except for a fair and impartial presentation of relevant facts, to aid the electorate in reaching an informed judgment regarding the bond issue or ballot measure, in communications otherwise permitted by law. So we're going to talk about it in a minute about what communications otherwise permitted by law means, but I think it's really important to emphasize those words: fair and impartial presentation of relevant facts, is what the exception applies to. There's also an exception for incidental and minimal use of public resources, which is like answering a phone call in City Hall and saying, well, no, you can't reach the campaign here, but here's how to reach them, or passing along a piece of mail, something like that. That's incidental and minimal use of public resources, which is not subject to this government code section. There's possible personal liability for $1,000 for each day the violation occurs, and up to 3 times the value of resources illegally expended. And I'm aware of public agency employees who have been found guilty of violating this section or liable for violating this section and have been fined significant amounts of money. It's very rare. I don't want to scare you. I'm not here to be a scaremonger. I'm just saying it's possible, and you should be aware of this government code section, as well as the fact that it applies to intentional or negligent violations. So if you're a supervisor and you don't pay much attention to what an agency's spending its money on, and you should be, it's possible to be charged with a negligent violation of this section. Next slide, please. Government Code Section 54964 is kind of the same concept. Not sure why there's 2 statutes, but there are. And this one is a misdemeanor. So it's possible to be charged with expending or authorizing the expenditure of public funds to support or oppose a ballot measure or a candidate, and to be charged with a misdemeanor for doing that. The next statute, and there are various ones that apply and regulations that Dave is going to cover in a minute. It's the FPPC's campaign reporting obligations. If a public agency makes improper expenditures to campaign for or against a candidate or a ballot measure, all of the FPPC's reporting obligations apply to those expenditures. And if you fail to report those expenditures, then you're liable for violating the FPPC's reporting requirements. The problem is, if you report the expenditures, you're also then reporting that you violated the first 2 statutes that I've talked about. So those 2 slides together kind of say you just shouldn't do it, because there are too many pitfalls to spending money in support of or opposition of a ballot measure or a candidate. Next slide, please. The last 2 statutes that are relevant to us, Penal Code Section 424 rarely gets charged, but it's there. It's a misdemeanor or a felony to misappropriate public funds for improper purposes. And I just found out about this other one in the last few days. I have not talked about this in prior presentations. Penal Code Section 72.5 makes it a misdemeanor to use public funds to attend a political fundraiser. And it specifically speaks in terms of reimbursement for the attendance at a political fundraiser. So if, for example, a public official wants to attend a fundraiser for a congressional member of Congress, we got to have good relationships with our member of Congress. We should support their fundraisers. Public agency can't pay for that attendance, and in fact violates Penal Code Section 72.5. I'm not sure that happens very much, but I did want to add it to the list of things to tell you can't do with public funds. You can't pay for tickets to a political fundraiser. Next slide. I'll turn it over to Dave.
Hi, everyone. Dave Bainbridge. I'm the general counsel here at the FPPC. I've been in this role for about 7.5 years. Prior to this, I was enforcement counsel here at the FPPC. So I used to investigate and go after people for these sort of violations, and now my role is more to educate and advise to avoid violations in the first place. This area of use of public funds for campaign purposes has been something the FPPC has focused on for about the last 10 years. Prior to that, there was very little enforcement by the FPPC in this area. As Craig mentioned, the FPPC's jurisdiction is limited. It's limited to requiring reporting of campaign expenditures. Public agencies that spend money for political purposes are required to report their expenditures and their contributions just like any other entity involved in ballot measures or candidate support. The other piece of it that the FPPC has is under the Political Reform Act, mass mailings that constitute campaign activity are prohibited. So the underlying issue of misuse of public funds is not something that the FPPC has jurisdiction over, but if you misuse public funds, we do have jurisdiction over whether it's reported properly. So it's kind of a strange dichotomy, but that's, as Craig mentioned, if you are having to report it, you've already likely violated the law. The controlling law, it's important to point out here, Craig had talked about the Stanson v. Mott case, and then there's also a Vargas v. Salinas case that informed the commission's regulations on this topic, but the actual law is the regulations. So I think that's important. I'll point out a context or two where the regulation, I think, is a little narrower than what the case law says, or at least could arguably be. So I'm going to talk about the campaign reporting regulation. The rule regarding mass mailing and when a mailer constitutes campaign activity is the same standard. So we'll just talk about the one for when you're going to trigger, when a communication is going to trigger campaign reporting requirements. But the test is essentially the same. Again, the mass mailing one is a prohibition. The other forms of communication require reporting. So regulation 18420.1 is the commission's attempt to define when you have campaign activity going on by a communication. So to distinguish communications that are educational and communications that constitute campaign activity. So there's two ways that a communication can be deemed campaign activity. One is if it contains express advocacy. So that's what we call the magic words: vote for, oppose, those sort of things, where it's clear that on their face what they're saying. And then two, the second one is the unambiguously urges standard. And so if a communication either contains express advocacy for a ballot measure or a candidate, or unambiguously urges a particular result in the election, it will be deemed campaign activity. Go to the next slide. So express advocacy, again, magic words, pretty easy to understand and see. Unambiguously urges is a little more less obvious. There's two ways in which something can unambiguously urge a particular result under the statute. First category is what's called clearly campaign material. So these are items that look like what you would get in the mail for any other campaign advertising, or that you would see bumper stickers, billboards, things that look like campaign. If you look at it, you ask the average person, what is this? They would say that's a campaign ad. So that's the first category. Again, a little bit easier to identify. I call it the glossy mailer test, because you only get glossy mailers if someone's trying to convince you of something. Agencies don't use those to communicate information typically. It's to convince you, whether it's to vote for a measure or to get your oil changed at a particular shop. The glossy mailer is what I think of as clearly campaign material, plus advertisements of the typical nature. The second test, beyond clearly campaign, if something is not clearly campaign material in its content or style, is what's called the style, tenor, and timing test. So under that test, you look at, based on the style, tenor, and timing of the communication, the item can be reasonably characterized as campaign material and not a fair presentation of facts serving only an informational purpose. So I think the most important word there is only. It can't be partially facts and then some advocacy. If that's the case, it's going to be considered unambiguously urging based on the style, tenor, and timing. So always keep in mind it's not some fair presentation. Some facts won't get you out of it. It has to be only facts serving an informational purpose. Okay, next slide. So then we drill down on what does style, tenor, and timing mean? And this is where Craig was saying it can often be hard to determine where the line is with education, informational versus advocacy. We look at all these factors to determine whether a communication is going to unambiguously urge a particular result. So style, you look at, does it look like a typical agency communication where they're providing information to the citizens, or does it look more like a campaign ad that's trying to convince you or drum up some sort of emotional reaction as opposed to providing information? The next one is tenor, which essentially means tone. You look to whether the communication is neutral and informational, or is it more argumentative, persuasive? Again, trying to solicit an emotional reaction as opposed to providing information. The last part of the test is timing. So if it's coming out in mid-October, sending out to all registered voters, that timing for a general election looks a lot more suspicious than something coming out in March of an off year. So all of these factors are considered. None of them are determinative. When evaluating under this test, you look at everything. And the regulation also includes a non-exclusive list of items to consider. So one is whether the communication is funded from a special appropriation or a general appropriation. Another one is it consistent with the normal communication pattern of the agency? Do they send out a quarterly flyer that talks about these issues, or is a special different sort of communication, again, a glossy mailer that wouldn't be typical of what the agency would send out in other circumstances? Similarly, is it consistent with the style of other communications by the agency? And then fourth, whether it uses inflammatory or argumentative language as opposed to language that is more informational. So that's the style and tenor timing test. We can go to the next slide. So if something is considered campaign material, in determining what needs to be reported, it includes not just direct costs, the cost of mailing or paying for the advertisements, but any indirect costs, so staff time, polling, anything related to producing the communication would be included in the cost. This can be important because there's certain thresholds for campaign reporting, over $1,000 for independent expenditures and over $2,000 for contributions that then can trigger reporting requirements. So good to know that anything related to a communication, either direct or indirect, can be costs that would be counted towards meeting those thresholds. There are, on the next slide, a few safe harbors for certain types of communications that an agency may want to send. So these sort of communications will not be considered campaign material. An agency report that evaluates a measure and is provided to members of the public upon their request. You'll see that a couple times in here. If it's provided upon request as opposed to pushed out to the public, that's seen as an important piece of information. The agency's position, an agency is free to take a position and announce that position at a public meeting on agendas on a particular ballot measure. It's not like the agency is prohibited from having a position or expressing it, but as long as it's done in one of these ways. The third one is the written argument. The agency can provide a written argument for a voter information pamphlet. Fourth is providing the department's view. So one is an agency report. The other is the department can provide its view on a ballot measure. If it's supportive of a ballot measure, they think it's crucial to the way of life in the city, they're allowed to put that information, provide that information again upon request. And then the last one is a catch-all if the communication is otherwise clearly and unambiguously authorized by law. All right, so if a communication qualifies as campaign material, it then, as we've talked about, triggers the reporting requirements of the Political Reform Act. Again, like any other participant in campaigns, the public agency would have reporting requirements. It also will make the agency subject to the advertising disclosure requirements, where you have to identify the source of advertisements for political campaigns. And then it also, there's that, again, the mass mailing prohibition. Mass mailing is defined as 200 or more similar pieces of mail that are sent out. So reporting for all other types of advertisements, and then the mass mailings are prohibited in and of themselves. Next slide, please. All right, so we're going to talk about an enforcement case here, and then an advice letter to help sort of provide some context and some examples of instances where jurisdictions have run afoul of the law, or where they actually haven't because they requested advice before sending out the communications. So the first one is in the matter of the County of Los Angeles. This was an enforcement case that the FPPC had. It came about as the result of a LA County tax measure in 2017 to fund their homeless initiative. It was projected to raise, I believe it was $300 million over a 10-year period. My recollection is it passed on a fairly close vote. It needed the 2/3 and got just a little over that. In that case, what we found was that the County of Los Angeles had hired a consulting firm who specialized in getting ballot measures passed. In fact, on their website, they advertised the fact that their success rate in getting ballot measures passed. They ran a TV and radio campaign, internet ads, and when you view these ads, they look very much like any other campaign ad you'd see. They had slogans. Their slogan was "Real Help, Lasting Change." Showed different images on the commercials. The commercials ran on cable television and talk radio. Some of the language from the ads, it identified it as the Los Angeles County Homeless Initiative. It had a logo. It said, again, "Real Help, Lasting Change" was their tagline. And then it said Measure H on the March 7th ballot. Are you ready? Vote March 7th. So very close to express advocacy there. But at the very least, we identified it as being clearly campaign material based on the nature of it. And the case ended up being resolved through a civil settlement where the county paid over $1 million for failing to properly report their campaign activity. The next example comes from what's called the Norton Advice Letter, and I've got the citation there if you'd like to look it up. It's on our webpage as well. So this came as a request for advice. So the FPPC will provide advice to agencies about whether a particular advertisement would trigger the campaign reporting requirements, as long as they ask before anything is put out into the public. We can't provide advice on things that have already happened. That once it's happened, it's into the enforcement realm. But in this case, the city of Riverside wanted to run an informational campaign and wanted to make sure they didn't go beyond the bounds of just being a permissible information campaign that wouldn't have to be reported as campaign activity. They were particularly concerned because they wanted to have a special election to renew this transfer of public utility revenue to the city general fund that had been in effect for many years. But there was also during the time of the governor recall election. So they wanted to make sure, and they had to run it on different dates for whatever reason. So they wanted to make sure the electorate was aware that these were two separate elections and that they understood the importance of this separate election that was unrelated to the recall election. So they sent us a number of different possible communications they were going to send out and asked us to weigh in on whether we would advise that they send them out or whether we would advise that by sending them, they would be triggering the campaign reporting requirements. So we'll look at a couple of these, go through sort of our reasoning at the FPPC for what we advised. We'll go to the next slide. Okay, so on the right-hand side, you see the white part. This was some information they wanted to put on their website. And again, where Craig had talked about where's the line, yes, the line can be difficult to find. And we would always err on the side of advising people not to do something if it gets close to the line. Our job is to keep people compliant with the law, not help them find exactly where the line is between advice and advocacy. So certainly there are arguments to the contrary here. But in advising them to ensure compliance with the law, what we ultimately concluded on this information that they wanted to put on their website was that it crossed the line into being advocacy. A couple important factors for us. One was the Measure C funds would raise money for the general fund. However, they pointed specifically to specific services that are generally popular uses of public funds as opposed to less popular uses of public funds. So police, firefighter, road repairs. Again, this wasn't restricted to the use for those items. It could have been used for anything general fund related. It also cited to some other generally popular uses of public funds below with the bullet points. And then the last paragraph we found to be more argumentative than informational. So ultimately, we concluded that they should not run this information on their website. The next item that they had us look at and provide our opinion on was an FAQ that they wanted to put out. And on this one, we came to the opposite conclusion, which is this is informational and not advocacy. The highlighted portions are similar to what you saw on the website before. One difference is on the website, they use the term it saves lives, whereas here they don't use such sort of, the same sort of language that could be seen as appealing to an emotional, making an emotional appeal, argumentative, persuasive, and more informational. Also, the content of this FAQ was broader than just telling you why we need to extend Measure C. They wanted to provide the information about why this is different from the state recall and why the two elections. And just so that's kind of goes to the tenor and the style of this is an FAQ, which is intended to be a factual educational document. So we told them that this was a permissible use of public funds that would not need to be reported as campaign activity. And then the last one is falls kind of somewhere in between the other two. It was a utility insert that they were proposing that you get in your utility bill. Usually provides information about bulk trash pickup or whatever the case may be. So in terms of the style of it, it's typical of a usual communication, usually an informational communication that an agency would put out. However, the content, when you look at it, we thought was similar to what they were proposing for the website. So they're highlighting popular services that would be benefited by Measure C. There's some somewhat inflammatory language in there. So we concluded on the whole that while this, it also, I believe, went out in the bills for probably September or October, right before the election was scheduled to take place. So the timing contributed to our determination that this would be campaign material, would trigger reporting requirements. Okay, so those are the examples. We have many more examples on our webpage of enforcement cases as well as advice letters we've written. You see the URL there. You can go there, take a look. We have a summary of the law. I would always encourage local officials and staff, if you're going to put out information about a ballot measure or certainly a candidate, consult with your agency counsel first. You can also take a look at our website, and if you still can't figure out whether it's something that would be informational versus would trigger your campaign reporting requirements, you can email us at advice@fppc.ca.gov, and we can provide you advice on how to stay compliant with the law. And that doesn't just apply to this issue, but any issues within our jurisdiction of Political Reform Act. We're here to keep people compliant with the law.
Okay, thanks, Dave. I guess I would say now we've kind of got the scary part out of the way. We've talked about all the different laws you need to worry about, all the enforcement consequences. And what I want to focus on is more what I would call tips and ways to think about these issues that will help you inform your constituents, inform the people who are making these decisions, while trying to stay on the right side of that line that Dave and I have both described. I think it's really helpful to have the FPPC's perspective on these issues, as they are the main enforcement agency. You can go on their website and read the enforcement decisions, the advice letters that they've given on a number of these topics, and see how they think about it. Let's talk about how we in the regulated community would think about some of these issues. So the concept of express advocacy. If you look at this, the first 1, 2, 3, 4, 5 lines of this paragraph, which is the definition that Dave showed you a minute ago about express advocacy, it's really easy to understand the first 5 lines, right? It's in law school, we all learned Justice White's definition of pornography, which is I know it when I see it. And it's the same kind of thing about express advocacy. We all know that language like vote for, elect, support, cast your ballot, vote against, defeat, reject, sign petitions for, all of that is urging a particular result in an election, and it's easy to understand why it's express advocacy and why government can't do it in the context of putting your thumb on the scale. Where we have trouble and where we have differences of interpretation and consultants, for example, that really want to push the envelope, is in this last phrase about unambiguously urges a particular result in an election, because there's a word "or" right here in the middle of the paragraph that it's either express advocacy, looks like these things, or it's a communication that taken as a whole unambiguously urges a particular result in an election. And that's where the enforcement decisions come up. That's where the lawyers who represent public agencies and are asked to advise on these issues get really nervous, because none of us really knows what unambiguously urges will mean in the minds of the people who enforce the law. And I think it's fair to say that the FPPC enforcement folks, all good people, all well-intentioned, as Dave said, trying to keep you in compliance with the law, certainly would interpret that word, those words unambiguously urge, more conservatively than a lot of other people would, and that's their job. But you got to keep in mind that that's their job, and that that's the way they would interpret those words. And I think Dave's description a minute ago of an agency using "quote unquote" popular expenditures to describe purposes of the measure is a key example. Like, I think we on the public agency would say, well, it's not necessarily that they're popular expenditures, it's that they're really important expenditures. It's what's important to our constituents. They want clean water, they want storm drain facilities, they want more law enforcement, they want better 911 response. And so you are telling people that this money will go to help the stuff that's really important to people in a community. Now, is that advocacy? There's a lot of room for interpretation in that context. But the conservative interpretation of unambiguously urges is why your agency lawyers will advise you to be cautious about the language and the style and the tone of the communications that your agency issues, rightly so. Next slide, please. There's a fine line between that express advocacy that unambiguously urges and what we would consider to be impartial information. Obviously, vote yes, vote no. We've already talked about that. Communications that are result oriented, something like when this measure passes, we will do the following. That's clearly unambiguously urging a particular result because you're not talking about the possibility of it not passing. If your communication is one-sided, is emotional, if you're showing emotion-driven photographs connected with the text, right? We need more money for 911 fire emergency and fire response, and you've got a picture of a burning house and a guy going up a ladder. It's going to be more likely to be judged to be an urging a particular result as opposed to just being information because it's trying to get a reaction out of the people that are reading it. I think another key indicator of targeted of express advocacy is targeted communications. If a particular communication is only being mailed to registered voters in the month of October or the month of November or the month, immediately before a primary election, well, that's really coming close to showing that it's trying to urge a particular result because you're not out there informing the entire community, and you're not informing the community at a time other than a few weeks before they're going to cast a ballot on your measure. So think about avoiding targeted communications, although I realize those are going to be more expensive, and think about the timing of your communications. What does it mean to be impartial? What does it mean to just provide impartial information? Well, for one thing, really factual communications are really safe. If you can state a fact and you can attribute the source of that statement, I think your communication is in really good shape. And so I urge my clients to think about communications that instead of saying this money is needed to pay for additional firefighters, I advise them to think about saying something like, the fire chief has reported that he needs more money to pay for additional firefighters. And if you can say the fire chief said that at a public meeting on September 21st, 2025, I think that's a lot better than just, we need more money for more firefighters. So I like to see a lot of factual statements. I like to see a little footnote, a little attribution of the source for that fact. And when possible, although I advise this a lot less than I used to, sometimes you can tell both sides of the story in this context. If this passes, we'll have more money to do X, Y, and Z. If it doesn't pass, we'll have to find that money elsewhere or reduce levels of service. I think that's a statement of fact. I think it tells both sides of the story. It's hard to say that it's partial. Again, widely disseminated communications, not just targeted to voters, are better than in this context than really closely targeted, especially if you go beyond targeting just registered voters. If you go to, well, we're only going to target male registered voters, or we're only going to target those people who consistently vote by mail, or those people who consistently go to the polls, or any one or a number of other targeting mechanisms that are available these days and that your consultants will urge you to think about. I think the more communication is targeted, the more likely it is that it's trying to unambiguously urge a particular result. And then I would say be consistent with the style, tenor, and timing, as Dave just talked about, of normal communications of the agency. What does that mean? Next slide. That means if you have city newsletters that have a particular style and they go out, every 6 months or every quarter, or the recreation guide or those kinds of pieces of information, the more your communication related to a ballot measure looks like that communication, the better off you are. The only nitpick I would have with Dave's glossy mailer rule, which I understand and agree with in some contexts is that some public agencies have some really glossy mailers as normal communications tools, right? You have a recreation magazine, you have that community information guide that goes out every 6 months, and they look great. The monthly newsletter, all of that stuff. If if your communication regarding a ballot measure is consistent with that style, then I think it's much less likely to be deemed to be advocacy. Utility bill inserts, a lot of agencies want to do that. A lot of agencies do that every month or every couple of months. This month it's a utility bill insert about upcoming construction projects. The next month it's a utility bill insert about changes in the garbage service, whatever it is. If you consistently communicate with your public through utility bill inserts, I think it's less likely to be viewed as being advocacy if you give them some information about a ballot measure in one of those months. If it's the only time you ever put information in a utility bill, then it's pretty obviously connected to an election. Tone and tenor, Dave talked a lot about, and I won't belabor the point, but we're looking for moderate, unemotional statements of fact as opposed to opinion. Um, and all of you who have been involved in a ballot measure before will know that the question that actually appears on the ballot, that 75-word question, does have those kind of popular or important government functions that show up in that ballot question to improve the city's maintenance of public streets and to provide disability access on public sidewalks. Shall a measure be adopted to raise money for those purposes? That kind of stuff appears in a ballot question all the time. Judges have approved that language as long as it meets the other format requirements. So I don't think necessarily emphasizing the purpose of the funds makes the communication to be improper, but I do think it has to be a statement of fact. It has to be a statement that avoids opinion. So you would say in a communication, to keep maintaining our streets would be obviously more permissible than to provide great street surfaces throughout the city, right? You don't want to use adjectives that are going to be deemed to be more emotional. I always try to get people to say if passed and not when passed. Just don't make that assumption. I think it's perfectly okay, especially with regard to bond measures, which are extraordinarily complicated and difficult for people to understand. I think it's absolutely required and absolutely necessary for a public agency to explain the process and what the vote actually means, because sometimes the question will just say, do you approve issuing these bonds? When in fact, what people are approving is paying a tax on their property to provide the revenue to pay off those bonds. And they're not just approving bonds. Giving those facts is certainly a key informational function of government. And this is kind of a random point in this slide, but I do want to emphasize it. There are two cases that talk about it being completely appropriate for public agencies to spend money on voter registration as well as get out the vote efforts, as long as they're not targeting, right? If in one case in the city of Irvine several years ago, city of Irvine spent a lot of money on get out the vote efforts, and it was all related to a county ballot measure where residents of Irvine felt a lot differently about the ballot measure than residents of other parts of the county did. And so Irvine wanted to get their voters to the polls. They never told them how to vote. They just said, remember, there's an election on a certain date, please go vote. And a court upheld that expenditure. So voter registration, get out the vote efforts in an impartial way are appropriate expenditures of public funds. Next slide, please. Again, timing, we've emphasized this already, but before the measure, versus after the measure. The LA County case that Dave talked about, they interrupted their normal communication cycles and they did a special budget appropriation at the same meeting where they decided to put the tax on the ballot. They appropriated $1 million for communications. So it was fairly obvious, even though they didn't connect the two in the two staff reports, that once they decided to put this giant tax measure on the ballot, then they hired a consultant for communications purposes and appropriated $1 million. The FPPC really noted that connection and said it's pretty obvious that the timing of these activities were related to the election, and that was a major factor in determining that the communications unambiguously urged a particular result in that election. Next slide, please. When we start a ballot measure effort for our clients that I work on, I try to give the client a do's and don'ts memo. And it's basically legal advice that says we think these things are okay in the context of a public agency ballot measure. And there are certain things that are clearly not okay. So let me give you kind of those lists. Permissible uses of public resources. You can clearly use staff, lawyers, even a consultant to draft a measure for presentation to your legislative body to decide whether or not it goes on the ballot. There's an FPPC advice letter that says you can spend public money to do a pre-measured poll to help the legislative body decide whether or not there's support. For example, if you've got a measure that requires 2/3 approval, it's permissible to take the temperature of your voters before you decide to spend a lot of money submitting a measure and paying for an election to see if there's a viability of that particular measure. Clearly, as Dave said, I said, you can use public resources to provide impartial information to people who request it, as well as kind of what we've been talking about, these normal communication cycles. You can spend money for voter registration and GOTV. A public agency board can adopt a resolution of support or opposition to a measure that's within their jurisdiction. And I strongly advise you to think about this if your agency is proposing a measure, for example. There's a case that says that as long as it occurs at a public meeting where everybody has a chance to talk about it, the legislative body can adopt a resolution of support or even opposition to a ballot measure. And that resolution of support can obviously state the reasons why that legislative body supports or opposes the measure. And so then, and you saw one of the safe harbors that Dave showed you in that multicolored, multi-box slide. One of the safe harbors is provide information regarding the agency's position in response to a request. So if somebody calls and says, hey, what does the city think about this? Here's a resolution that says the city council urges you to vote yes, and here's why. Now, you can't mail it out to everybody. You can't use it for, campaign purposes, but it is a way for the legislative body to express its opinion on a measure and explain why it is taking that position. And it's a really good opportunity to get out a message. You can also prepare answers with impartial information to anticipated questions so that the person who answers the phone or who is in charge of responding to requests for information has the kind of approved answers to those questions and can give the city's or the public agency's response to requests for information about, hey, what does this measure mean? How much would I pay? When does it end? Those kinds of questions, you can prepare those responses because you need to be able to answer your constituents' questions. Next slide, please. What's prohibited? Production and printing of campaign literature, whether for a ballot measure or for a candidate. As Dave said, we all know when we see it. If that's a campaign flyer, if it's got lots of emotional photographs, it's got pictures of kids, letting the balloons go in the park, or cars driving through potholes, or flooding or fires or whatever, if it's got a lot of artwork that's intended to create emotion, that's going to be looked at as a campaign mailer. If it's a button, if it's a bumper sticker, you can't spend public money paying for that. You can't spend public money paying for digital advertising that is connected to a ballot measure, because as the FPPC and a court said in the LA County case, public agencies generally don't engage in digital advertising. If you just start doing Facebook ads or Instagram posts or TikTok reels or whatever they are in connection with an election, that's a campaign activity because it's not a normal communication. So you shouldn't really be paying for digital advertising. You can't let campaigns use public equipment, facilities, supplies, technology. That also means don't let them use your fire truck for a photograph or something like that. That's an impermissible use of public facilities, public equipment. You can't distribute campaign material in the library or in the city council chambers or in the bookshelf in the front of City Hall. You can't engage in favoritism or discrimination against a particular message. If people want to come to public comment and give their 3 minutes of opposition to a ballot measure that the city council has put on an election, they need to be able to speak just as somebody else would come in and say why they favor it. And as Dave said, and I think this is really important, be careful about mass mailings at public expense. There's a separate section of the Political Reform Act, a separate regulation that says you cannot spend public funds on mass mailings, which is more than 200 pieces of mail in a calendar month that features an elected official. So you can't put the elected official's photograph, you can't put the elected official's signature, you can't put an article written by the elected official, and you certainly can't put an article about advocating for a ballot measure in a mass mailing at public expense. That's a separate violation of the Political Reform Act. Candidates often want, or public officials often want, their picture at the ribbon cutting, or to put their own article in the city newsletter or the recreation brochure or something like that. You can't feature a public official because it provides them a political advantage. It provides them visibility in a mass mailing that's sent at public expense. And you certainly can't do it with regard to a ballot measure either. Next slide, please. With regard to public employees, here are the things you really can't require public employees to do. They cannot be required to work on campaign activities during their compensated time, and they cannot decide to do it on their own. There may be people who in your organization who really think that a sales tax increase should be approved because that'll provide more money for employee salaries, for example. That's great. They are entitled, they have the right to have that opinion. They can't do it anything to disseminate that opinion while they're on work time. They can't campaign either in City Hall or your agency's headquarters, and they can't campaign or engage in campaign activities during compensated time. They cannot be coerced or directed into working on a campaign in their off hours. So the department head can't say, hey, there's a big rally for the sales tax measure and the city council wants everybody to be there on Saturday. Can't do it. You can't coerce people to participate in a political activity in their off hours. If they want to show up on their off hours, if they want to walk neighborhoods, if they want to hand out flyers at the farmer's market, that's their First Amendment right to do it as long as they're doing it on their own time. You cannot force them to do it. They may not use district or city resources for or the technology for campaign activities. No copying of flyers, no putting stuff out on computers, no making phone calls on city phones for either candidates or ballot measures. And they may not campaign while in uniform. There's a specific statute that prohibits campaign activities by a public employee in uniform. for any purpose. Next slide, please. Public employees can't circulate petitions on official time. And so you connect that with they can't campaign in uniform. That really says public employees, if they're going to engage in political activities, they got to do it on their own time and in their own clothes. There's a ballot measure circulating right now in the city of Los Angeles, for example, I read about that the firefighters union is circulating, and those firefighters cannot circulate petitions on their own compensated time. They can't do that campaign activity in uniform. Public employees, especially supervisors, may not solicit directly or indirectly a political contribution from another employee or officer. If there's a campaign in favor of a ballot measure, a supervisor can't, at the staff meeting say, hey, just want to let you know that there's campaign activity going on and we need to raise some money for it. And it'd be a good thing if everybody contributed a few bucks. Here's an envelope. You can't do that in the public employment context. So we cannot solicit directly or indirectly, and we certainly can't allow our elected officials to sort of walk through City Hall and hand out the campaign envelopes and say, "Hey, remember how good I've been to you in terms of voting for your salary increases." That's clearly illegal and can't be done with public employees. They can't be solicited for a contribution. Like somebody might want to mail a fundraiser invitation to their home. Public employees cannot be solicited for a contribution unless it's almost by chance as part of a broader appeal. If an elected official sends out a solicitation to an entire community and that employee lives in the community and isn't targeted because they're a public employee, that's okay. But public officials cannot solicit their employees or the public agency's employees for a contribution. And nobody can be promised employment action in exchange for a vote. Nobody, and a common example of this is supervisors can't say, hey, if this sales tax measure passes, we're all going to get raises. So everybody get out there and campaign for it. There are limited exceptions for union organization activities because those involve elections, but there are exceptions for that. And a violation of it, these particular laws on this page are all can be misdemeanors. Next slide, please. So when in doubt, like how do you sort of synthesize all this? If you're in doubt as to whether a communication is lawful or unlawful, it's probably advocacy. If you're motivated by a particular result in an election, and you say to yourself, boy, I just don't know if this crosses the line or not, it probably crosses the line. And the stakes are too high to push the envelope, especially whereas I say there are ways that to lawfully get your message out. And if your message is compelling enough, it'll sort of get through the noise. But the stakes are really high for crossing the line. There are criminal penalties, financial penalties, potential disqualification from holding public office, or discipline or termination as an employee. So, pushing the envelope is a high stakes endeavor. And as Dave rightly said, consult with the agency attorney in advance. And on behalf of agency attorneys, I would say take the agency attorney's advice. I think sometimes we agency attorneys feel like we have to be a backstop, and that there are especially consultants out there who are really pushing for some kind of risky behavior, and we tend to try to push back. And I would suggest that it's in your agency's interest to err on the side of taking the agency attorney's advice as opposed to the consultant's advice. And that's not to demean consultants. They have a particular role, but they do market themselves in terms of how many measures they have successfully passed. And so they do have a motivation of getting your measure passed. That's a plug for your agency attorney. Next slide, please. Ways to get the message out. First and foremost, I advise clients all the time that one of the main things elected officials can do to help in this regard is to organize a private campaign group. If if people think that a public agency needs more revenue for law enforcement purposes, for example, well, the people who really want more law enforcement resources in a community should get together, form a campaign group, find the funding, and campaign in favor of that measure. If they want a measure passed, they should be willing to work for it and do it through the lawful intended format of forming a campaign committee, raising money, and spending public funds to advocate for or against a measure. I realize that is a, very aspirational thing for me to say, and um, city managers in the group and district general managers in the group are all shaking their heads at me right now because, there's not a lot of people who want to pony up for the cost of a campaign, but that's the appropriate way to really campaign in favor of a local agency ballot measure and the way to not have to worry about these laws that we've talked about in this session. Inform the public about ballot issues in an impartial way. As we said, you can inform them about the city council or your legislative body's position on the measure and the reasons why. But do the rest of the communication in an impartial way. And if the message is compelling enough, if you've established the need for additional resources, for example, the financial reasons that the city council has decided to put a revenue measure on the ballot, or for whatever else the ballot measure happens to concern, the impartial presentation of the facts will be compelling, and people, voters generally get it right. Make your staff available to respond to requests for information. Provide them with FAQs and answers in advance. Make sure you designate in your staff structure who's responsible for responding to requests for information. Because if anybody can just answer a question, the risk rises dramatically that somebody's going to be really enthusiastic about a ballot measure and give you give the questioner responses that probably cross the line, and do the organization of a campaign activity on your own time, or on elected officials' own time, for example. Those are the main ways to get the message out. And I think, as I said before, if you create a compelling, impartial message, and most of our stories are very compelling in the local government field, you'll have success with getting those out to voters. Next slide, please. I know we're going to have a lot of questions that are kind of come up for both of us. I see them in the Q&A. Just to cover stuff that comes up a lot in these sessions really quickly. Can a public agency sponsor a candidate forum or a town hall meeting? The answer generally is yes. Ask your agency counsel about this, but there is a reg that says using a public agency facility for a candidates forum or a town hall meeting on a ballot measure, for example, is permissible as long as everybody is invited to participate. You can't just have the mayor give a speech and not invite the person who is running against the mayor. One of the things Dave talked about is the kind of safe harbor is a legally required communication. A ballot argument in favor or in opposition to a measure is specifically provided for in the elections code. So writing that ballot argument is a permissible expenditure of public resources. Can you use photographs or video for campaign purposes if they were paid for by a public agency? If they're public domain and somebody can just go on a website and pull them down for any use, I don't think the public agency has liability for those for whatever they get used for. I've always advised against hiring photographers or videographers specifically for campaign purposes. I think that's an impermissible use of public resources. Can you have information booths at public events? If you have an impartial piece of information, like here are the facts about Measure A, certainly I think is permissible to set up a booth. And if people come over and want to ask for it, do you have any information? Yep, here's a FAQ document. I think that is permissible as long as it's, as we say, impartial. Be very careful about information on public websites. There's a lot of controversy about whether, the public agency has to link to both sides, both campaigns, both candidates. I just think that kind of activity is really fraught with complications and would not link to campaign websites or campaign information on public websites. And in most cases, campaigning on public property, you should ask your agency attorney about, but there's a whole line of cases about political activities in public forums versus limited public forums. Can people campaign in the public park? Sure, they can. It's a public forum. You can engage in political activity. Can they come march through the halls of City Hall? No, probably not. So there's a whole kind of range of answers to that question. And that's one you should really encourage staff to talk to agency counsel about before somebody wants to schedule a political meeting, for example, in the library's community room. That one is a First Amendment issue that has a whole bunch of layers to it, and you should be really careful about seeking advice in advance. Melissa, do you want to go on to audience Q&A?
Yes, so let's go ahead and move on to our audience Q&A, and we have quite a few questions already in the queue, but if you have anything that comes up as we have this discussion, please drop them in and we'll get to as many as we can. So I just want to ask about a bright line between when it's preparation, just Craig, you talked about this in terms of preparation for an initiative versus when it becomes advocacy. Is there a bright line that you can share with folks in terms of when does it transition from, okay, you're preparing that language and the ballot measure into when it would become more of an advocacy issue?
Well, I would welcome Dave's weighing in on this one too, because I think one or two advice letters have kind of moved the line a little bit, in my view. But we've for years have said until the city council let's use the city council as an example. Until the city council takes an action to put a measure on the ballot, there's not a clearly identified ballot measure because we're talking about concepts and we're talking about different elections and a whole bunch of variables. I think that the FPPC is probably has less of a bright line on that than we used to. So, Dave, do you want to jump in on that?
Yeah, our focus would be on communications being put out. So conduct that goes on, polling, all of that before any communications are produced and sent out. Until there's a communication, there's really nothing there for us because the campaign activity is based on communications. Once there is a communication, well, some of that prior activity may be associated with the ultimately producing the communication. So I would say activities before any communications are sent out to the public are not going to trigger any reporting requirements. But once there are communications is when you look to see if the communication is including advocacy.
Yeah, because one of the things that's happened in my experience more recent years is we've always said, I think the advice letter from the FPPC that says it's okay to pay for a poll is probably 20 years old at this point, or certainly more than 10. But what's happened lately in the last few cycles, in my experience with uh, consultants getting more involved, is the consultants want to send out communications before the poll is taken to sort of, I guess, soften the battlefield a little bit, educate the voters before there's a poll taken. And that's before a city council decides to put a measure on the ballot. But that communication might be viewed as being directed toward a clearly identified ballot measure because the purpose of the communication is to get the voters interested in a potential ballot measure. So that's why I say it's not the same old bright line of the rules change the day the city council puts it on the ballot now because we're having these communications that take place before there's a ballot measure. And I think it's hard for staff and especially kind of with the consultants pushing on them to really think in those terms. But it's not necessarily just the day that the action is taken to put it on the ballot anymore.
But that would also obviously be an indication of a move to advocacy as well. There may be activities before that that they need to be careful of, but that would be a good
Yeah,
anything happening beyond that
yeah,
at
I think
point in
that
time.
pre-poll communication that we're seeing more of now is definitely covered by the rules that we're talking about, even if the action has not been taken yet to put the measure on the ballot.
Okay. There's a number of questions about the communication types that you all talked about, and that litmus test, if you will, of tone and tenor and timing. Um, is there any guidance you can provide in terms of a threshold or a cadence um, that folks should be aware of? So maybe they are experimenting with a new communication method at their city or their county or their district. Um, is there any kind of threshold that you could indicate that it would no longer be a bright red flag for you as you're reviewing communications? Dave, Craig, either of you have thoughts on that? Or Craig, you used the example of the boosting social media posts. If that's a new strategy that agency is undertaking, um, just any thoughts on how long something has to be tested before it's an official strategy that the agency is using?
Yeah, I'll weigh in on that first. I think there's what can make this sometimes tough for the agencies is it's a totality of all the circumstances. So there aren't a lot of bright line rules. We wouldn't say it's never okay to send communication that's different from types you've sent in the past. It's just one factor that may be looked at that could lead you to believe that you're attempting to influence as opposed to providing informational material. I would say if it is a new form of communication that you haven't used in the past, you would be extra careful in ensuring that it is factual and doesn't in any way appear to be advocacy.
And and I think that's great advice that, you sort of if one of the factors is a little elevated, well, that's reason to dial back on the style. Or if the style is elevated, you want to dial back on the tone, right? It's a balancing to some
Mhm.
extent. To me, and the thing I learned from that LA County case that I have consistently advised on, I think, if I was an FPPC enforcement lawyer, the thing I would look at is the budget appropriation. If you're deciding to spend money on communications and your normal budget time in June, as part of the annual budget, that's one thing. If you decide to spend extra money on communications, in August after you've decided to put a measure on the ballot in November, it's a lot easier to look at that and say, well, that's for helping to get the measure passed, right? So I think planning ahead and thinking about communications, especially communication changes, is best to do well in advance of when a ballot measure might be being considered.
Okay, thank you. Um, there's also a number of questions related to the distinction between elected officials and staff. So you both talked about staff, use of staff time as, while you're on the clock, et cetera. Um, what, if any, of that extends to elected officials as they're campaigning, whether that's for or against a measure or for or against themselves as a candidate?
Well, I think it depends on how the elected official gets compensated. If, for one thing, if, big city where you have a full-time city council that gets paid a salary for full-time work, well, they're the same in this context as a city employee, right? They're always, when they're on the clock, they're on the clock. But most of our elected officials across the state are part-time and are compensated very little, and they're not really typically on compensated time, except maybe when they're sitting at a meeting. In fact, like special district directors are paid by the meeting. So they're not really on the clock when they're doing other activities. And I would argue, and I don't know what the authority for this is, but I would argue that public officials have a First Amendment right, as long as they're not doing it while they're an employee of a public agency, to say what they want to say about political issues. And I think it would be very difficult for them to be prosecuted just for the use of their time. Now, that doesn't mean they can use public resources, cars, phones, whatever. But I think the compensation issue is a lot different than it is for employees.
Dave, anything you want to add to that?
No, I agree.
Okay.
Officials are certainly allowed to express their opinions, even on ballot measures. They just can't use public funds to get communications out there in support of them beyond and if they do, it has to be reported. But no, they certainly can express their opinion. And the boards as a whole are allowed to express their opinion in various ways, as long as it doesn't become advocacy.
Okay, I think we've got time for maybe one more question. So I've seen a couple variations of this come in, and Craig, you definitely addressed this a little bit in your last slide in terms of that candidate forum piece, but just any guidance on allowing proponents of initiatives or folks to speak for or against ballot initiatives at public meetings. So if you invite one side, do you need to invite both sides if it's a public meeting context around, so say there's a ballot initiative around a sales tax increase and you're holding a community meeting to get feedback on it, would you need to invite both sides to that forum, or any thoughts on that?
Well, if
it's a city hosted.
Yeah, I mean that's the issue. If it's a city hosted, I think I don't recall off the top of my head, but I believe the reg, and Dave, maybe you know this, there's a reg that says it has to be a candidate forum has to be hosted by like a recognized nonprofit, and everybody has to be invited. The ballot measure thing is a little different, but I still think if you're only making a facility available to people who agree with you, and prohibiting people who disagree with you from using a public facility, that's going to be problematic. Now, in a lot of these ballot measure campaigns, you don't know who the opposition is, right? There are people who go out and vote no, but there's not an organized opposition group. So that's, it's not really possible to reach out to the campaign in opposition to your ballot measure. The other thing I would always advise is I draw a distinction between campaigning from the audience portion of a public meeting, getting up at public comment and saying what you think about a political issue, and campaigning from the dais. I don't think public agency officials should campaign, say something in favor or opposition to a ballot measure when they're sitting on the dais and using the public agency's microphone to express their opinion. But if people get up at public comment and want to talk about your agency's ballot measure, I similarly wouldn't prohibit them from doing it just because they're saying vote no or vote yes. I think that's another First Amendment public comment kind of issue.
Another one of those context specific.
Yeah, but definitely talk to agency counsel about it, because there is a reg that I just don't have off the top of my head about, it's an FPPC regulation about campaign forums and the use of a public facility.
Okay. We can also look that up and share that information with folks in our follow-up email. So we are unfortunately at time. I know we have a lot more questions that we didn't have time to get to. So I will work with Craig and Dave to see if we can get responses to some of these out with our follow-up materials. We also, ILG has a resource that covers some of the basics on this in terms of the do's and don'ts that we've worked on over the years. And so we'll also make sure to get that out to all of you as a reference following today's session. Just a quick plug for ILG. If you aren't connected with us in these ways, please join our networks in terms of our newsletter or social media channels. It's how you can stay up to date on resources that we're releasing or new webinars and trainings that we're holding in this space or in others. As I just mentioned, we will be sharing the recording and related resources and materials with you all via email in the next few days, so stay tuned for that. And I will share our contact information here in case you want or need to follow up with any of us after the fact. But I just really appreciate you all spending your lunch hour with us, and I want to thank Craig and Dave for sharing their wealth of experience and expertise in this space with all of us this afternoon. Craig, Dave, any closing thoughts before we let everyone go for the afternoon?
No, thank you for having us and really reach out to us. We're here to keep people in compliance. So don't hesitate to contact us.
Same. Thanks to FPPC, Dave, and Melissa and ILG for putting this on.
Perfect. Okay. Well, thank you, everyone, and hope you have a great rest of your afternoon.